and organised. So let's get started then. Well, welcome everyone. My name is Laura Payton. I'm a Senior Associate Solicitor at Ridouts. Welcome if you're joining us for the first time, and welcome if you're back to the final episode in the series of Ridouts Autumn webinars. This morning I'm joined by three of my colleagues in a slightly longer session. It's a 1 hour session today. My colleagues Jenny Wild, who's a director at the firm, Paul Ridout, who's our managing director, and Anna, who's an associate solicitor, will be delivering 3 presentations this morning. The first will be a CQC update, particularly around their new Transitional Monitoring Approach. The second presentation by Anna will be on the Mental Capacity Act and the Liberty Protection Safeguards. And the final session will be from Paul, and he's going to talk about some lessons learned from COVID-19 and the way forward. Now, the way the session is going to run, the 3 presentations will run back to back, and then at the end, there will be an opportunity for questions. Now, if I could ask, if you look at the bottom of your screen, there is a little question and answer box. So if, as you're going through, you have any questions that pop to mind, please do put them in the question and answer box rather than the chat function. And I will be collating all of them to put to the panel at the end. But worry not if we don't get to your question, as we often don't, because we get lots and lots of questions. We've already had some in advance, and we've added a new section to the Ridouts website, which is a resource for providers with some Q&A, and we will endeavour to take as many of these back to that as we possibly can. And the final thing I would say is just join the conversation on Twitter as well at the same time. The Ridouts can be found at Ridouts Law. So without further ado, I will hand you over to Jenny to give us the first presentation of the morning, which I'm sure will be very informative.
Thanks, Laura, and welcome everybody. This morning I'm going to be giving you a whistle-stop tour of the CQC's current happenings, the developments over at the regulator, and what we as solicitors have noticed. As Laura mentioned, we are going to be covering the Transitional Monitoring Approach, but also we're going to be looking at the ways that CQC have been inspecting people over the last month or so. And we think there are some really interesting points there for providers to note and just be alive to. So what's currently happening? We're going to be looking at what is happening on the ground. So really it's practical things that people need to be noticing, be aware of, and understand how to deal with. The Transitional Monitoring Approach is a significant part of that. We're also going to be looking at a notable increase in enforcement action and just a little bit around infection control inspections, which are having serious consequences for providers. So the Transitional Monitoring Approach, also known as the TMA. Now this is quite a detailed part of the presentation, and unfortunately will be a bit of a gallop, but the slides will be available, so don't worry. Now, what is the TMA? Now, in the wake of the pandemic, CQC has had to change its entire approach to inspections, and that's in order to reduce the number of people going across the threshold into care homes and care services with a view to limiting cross-infection. Now, since the 6th of October 2020, CQC is now going to do a more arm's length approach to inspection. What they're going to do is start proceedings in a more remote way by having a conversation with providers, either online or on the telephone. And during this conversation, the CQC inspector is going to ask questions that will focus on specific CLOEs. Now, the existing CLOEs are what we're all used to, what we're all familiar with, but what they're going to do is actually emphasize in particular safety, access and leadership, and also generally some issues around the 5 key questions, and it's a pick and mix really. They can pick whatever they like. This is going to enable the CQC to be more targeted and responsive, and we all know what that means. Essentially, targeted and responsive means reacting to information that they get and looking for problems that they've generally had a sniff of. Now, during this monitoring call, the inspector is going to record the discussion around the questions that we just noted. And what's going to happen is specific risks that may crop up will be identified, but also we would urge providers to, in those conversations, really hammer home examples of good practice and improvements to the service. All of this information is going to be gathered and reviewed, as well as other bits that CQC have prepared in advance of the telephone call. So other sources of information that the CQC might have will be previous inspection reports, monitoring information collected through data sources and other third-party stakeholders. So that could include the local authority, the CCG, whistleblowings, and also the inspector's knowledge of a service. Now, I'm sure what you're thinking is, oh, I don't have a particularly good relationship with my inspector, if you're lucky enough to be in that type of relationship. So the concern is that you might be setting off on a negative footing, but we're hopeful that the variation of information available will create a more rounded impression to the CQC. Now, once all of this information has been looked at, the CQC are going to determine the level of risk through the phone call, and on that basis, decide what action needs to be taken. So will they determine, well, actually, we need further information. So we're going to do some interviews on the telephone with service users. We're going to speak to staff members. Or are we going to undertake an on-site visit? Now, not every phone call is going to result in an inspection. So that's something to bear in mind, and we'll get to that in a second. Now, there's already going to be a slight imbalance here. CQC are going to be focused on providers where the CQC has concerns. So the old adage of we're coming in looking for good, and good being a benchmark, is a little bit abandoned, because actually what they're doing is inspecting based on a trigger or a risk or a concern. So that already sets things out on a negative path. CQC are going to try and do this to look at risk, but also minimizing infection control risks. But really, we have a few concerns about how that's going to come out in a final inspection report. Yes, it's CQC are going to be well targeted and driven by the information that it has, but actually an inspection on that basis is only going to be as good as the information that the CQC already hold. And generally, information that CQC has about you is going to be revolved around concerns, negative feedback, or people that have complained. And that's just the way that it is. Very rarely do people contact the CQC to say, that care home is fabulous, or I've got some great things to say about Oak Tree Manor. Unfortunately, it doesn't happen like that. Now, following that view, as we've noted, CQC will determine the risk level. If the risk is high, they will be visiting the service. If the risk is not, they will not visit the service. If monitoring activity does not lead to an inspection, CQC are going to use its existing methodologies, which means it can look at all of the CLOEs. However, inspections will be targeted and focused around areas of risk. And again, there's this focus on the negative, on the risk. As a result, inspections may not always lead to a change in an overall rating for a service. This is a clear departure from CQC Timetable Inspections. And we at Ridouts have heard a lot of concerns from our clients about what this departure means for their businesses. Looking at the previous CQC guidance, there was a very clear structure of inspection, and people could feel comforted by the fact that they knew that they would be re-inspected within a certain period of time. So even if they performed poorly, they knew that CQC would come back at certain intervals, and then the potential would be that their rating would change. So previously, inspections were expected to take place within 30 months of publication of a report for a good or outstanding service, within 12 months for a requires improvement service, and within 6 months for a service rated inadequate. But let's all remember, CQC could come in at any point during that period. This was just a loose structure. Now, the important thing to know in departing from that frequency grid is that people's ratings can now remain unchanged for a long and indeterminate period of time. There is no certainty anymore. Now, if you're a provider that is rated as outstanding, then that's great news for you because you're performing exceptionally well. You're probably not going to be inspected as often because your risk will be low because you're an outstanding service. And so you will be able to sustain that rating for a much longer period of time. People who are rated as good could also be content with this new approach, because if you're good, then that will remain in place for a while. However, for some people who are good but think that they are building up to outstanding, this will be a huge frustration because, again, because you're good, the risk is probably lower, and that's the perception of the CQC. And on that basis, you're less likely to be re-inspected because of the low risk. So when are you going to get your opportunity to prove to the CQC that you're outstanding? That's very disappointing. Now, unfortunately, the people most negatively impacted by this new structure are people who are rated as requires improvement or inadequate. Those people who believe, okay, yes, we will requires improvement or inadequate, we've really upped our game, we've turned things around and implemented a number of systems. They're going to think, well, actually, I am not going to be re-inspected within the 6 months that I expected or the 12 months that I expected. So when am I going to get my opportunity unless there is a specific risk? So again, there's a little element of unfairness there. Now, as we all know, people with ratings such as requires improvement or inadequate do have a competitive disadvantage to other providers within their locality with better ratings. People going to look for care services are less likely to use requires improvement or inadequate services in comparison to outstanding or good. And CQC's new approach is almost robbing these people of the opportunity to prove how they've improved and changed. Now, we've had a number of clients who have fallen into that category and said, well, yes, okay, we were requires improvement back in February, but now we're better, we're definitely good. How can I instigate the CQC to come back and inspect? Now, unfortunately, you cannot compel the CQC to come back and inspect a service. You cannot force them. You can absolutely request it, and any evidence that you have about changes and improvements should be shared with the CQC. But again, in keeping with the CQC's new approach, the CQC are unlikely to prioritise the inspection of a service that's performing well because it does not suit risk and it doesn't fall in line with the TMA. So very many providers are going to be stuck between a rock and a hard place. So what can be done about this? Yes, we understand the reason for the TMA. Yes, limiting infection is the right thing to do, but what can be done? Now, we're suggesting that providers who are awaiting inspections or who are going to be contacted by the CQC to instigate whether or not an inspection will happen should keep the channels of communication open with the CQC. Yes, positive relationships with inspectors are very important, but not everybody is lucky enough to have that. But we would say, keep in touch with them. Ask your inspector when they intend to come back. How are things looking in the local area? More importantly, deliver to that inspector positive feedback and help the CQC build their remote profile. Remote information is going to be the absolute bedrock of your inspection. And as I've noted, it's just the nature of the regulator that most of the information they will hold of you is likely either neutral or negative, because people don't necessarily share positives about your care service. So on that basis, you, the provider, should be the one sharing with the CQC all the positives that you've kind of encountered at your home, the feedback that you've received, new systems that you've put in place to give them a rounded picture of your service. Don't allow them to only have the negative information. Now, that was a very whistle-stop tour of the TMA. And that is going to kind of come out of the wash in the months to come. But what we've seen in the here and now is what I'm going to move on to next, and that's a serious increase in enforcement action. Now, we've really seen a sharp spike over the last, I would even say, month of urgent action being taken against providers. As you all know, the CQC kind of went dormant for 3 or 4 months. But unfortunately, they are now back with a vengeance, and I'm sure that my colleagues will agree. We've seen an increase in Section 31, and that's urgent enforcement action, where no proposal is given, the action is just taken instantly under Section 31 and takes immediate effect. Now, urgent action under Section 31 can vary a provider's registration by adding or amending conditions to your registration. This might not sound like a big deal on the face of it, but actually it can have really serious consequences. So we've seen conditions added such as a restriction on admissions without the prior consent of the CQC. That didn't only relate to new service users, but it also included service users that had gone out to hospital and then would come back to the home, and they would not be admitted back into their own home without the prior consent of the CQC. Now, that condition is not workable, and we actually succeeded on appeal to have that decision rescinded because it was unreasonable in nature. But these are the kinds of conditions that the CQC are capable of imposing. Also, positive conditions requiring you, the provider, to produce weekly reports or weekly action plans, furnish the CQC with information, not just on an informal basis, but they will make that a condition of your registration. So if you forget to do that one week, or you provide something that isn't what they're asking for, you are effectively in breach of a condition of your registration, which, as you know, has serious consequences. Now, often before CQC take action under Section 31, providers receive a letter of intent, and that's actually giving the provider the opportunity to respond to action that the CQC is considering taking. Now, this letter should be regarded as a last chance saloon. It's your last opportunity to deter the action. So the letter looks quite informal, but it will say letter of intent across the top. It will say CQC is considering taking urgent action against your service, and it will list all of the concerns that the CQC will use to justify that action. Usually, when you get a letter of intent, the CQC will require a response in a very, very tight frame of time. Now, we've seen somebody get a letter like that at 5 p.m. on a Wednesday, and they will have had to respond by 10 a.m. on a Thursday. So not just a response to the letter, but also the production of a detailed action plan addressing every point that the CQC has raised. It is imperative that you stick by the CQC's deadline if you want to try and deter the action. The action plan is highly important. If the action plan is detailed enough, it has smart objectives, it has details of who owns each task, then the CQC are far more likely to not take the enforcement action because you will have restored their confidence that the action plan addresses all the concerns and that the level of risk no longer requires the action to be taken. And the level of risk required under Section 31 is that there is a risk of, or that service users are at risk of any kind of negative element of care. So it's very broad, but if you can negate that risk through your action plan, then the CQC are far less likely to adopt their approach to taking Section 31 action. If they do not like your action plan, they will immediately issue you with a notice of decision under Section 31, and that decision takes immediate effect. So from the day you receive that notice, you will have to do what the letter says, and you will have to comply with the conditions that have been added to your registration. Now, it's really important to issue well-considered responses to letters of intent, and you have to produce that under pressure. The letter actually says that you ought to take legal advice, and I would say this as a lawyer, but would strongly recommend that you take legal advice. This is not a case of just providing the CQC with any type of action plan. This is now veering into legal proceedings. And I think that having a lawyer often demonstrates to the CQC how seriously you're taking something and that you're committed to improvement and change. And the reason why they suggest you get lawyers' advice is because if the CQC do issue you with a decision, the only way to kind of appeal that is through the tribunal. This is no longer an issue for the CQC. It goes straight to the tribunal, and that's the first tier tribunal care standards. And then you are officially in legal proceedings. Now, we all know that legal proceedings are costly to providers, but they're also costly to the CQC. So the letter of intent is actually offering you, the provider, another chance to get out of the problem. It's the CQC saying, okay, we want to panic you into taking action, but we're either not sure if we've got a great legal case here, if this does end up in a tribunal, or we think that you can remedy this quite quickly and we want you to take that action. CQC want you to succeed with the letter of intent. They want you to put forward a good action plan, because that avoids legal proceedings for everybody. Now, it's worth mentioning that the CQC are not actually obliged to issue you with a letter of intent. It's not a requirement, and that's all increased in recent years, I would say, and months. CQC can just simply issue you with the Section 31 decision that will take immediate effect. So in that situation, if you wanted to appeal it, you would just have to go straight to the tribunal. You would urge providers to take this opportunity and be seriously considering the quality of an action plan and the robustness of a response. Now, finally, I just wanted to touch on infection prevention and control inspections, which we've seen a huge increase in. Now, it's understandable that these types of very narrow inspections are happening. You see much shorter site visits. Inspectors will speak to staff on the phone before or after the inspection, and smaller issues noticed on the day of that inspection can add up. I had a client with an inspection report recently who had been given they were good in every area, but they had been given an overall rating of requires improvement, and only one domain had been rated as requires improvement. And the only negative thing in the report was simply that a staff member had been seen to be wearing their mask under their nose. Now, that's quite right. That goes against infection control protocol, as we all know. It should be removed like this. But that downgraded the rating for the entire service. So small things that staff are not doing, particularly in relation to PPE, very hot topics at the moment. Now, what we would say is that we noticed during these inspections that CQC's own staff are failing to follow infection control procedure and protocol. We've had issues with inspectors wearing 2 pairs of gloves, disinfecting gloves and keeping them on all day. So on that basis, we think it's important that you as a provider take a detailed note of what you observe through the CQC's inspection, because again, you're preventing risk to your service users. Shadow the inspector and ask them if there's anything that's an immediate concern to them, because all too often the findings are either not shared or no concerns are raised at the end of the day. And so inspectors think, well, actually that went quite well. No feedback should be a surprise after the inspection. You should know exactly what's happening and force the CQC to share with you things that are going wrong so you can put them right in the here and now. You will receive a draft report, and as usual, it can be challenged if you disagree with the findings. So in conclusion, there are lots of changes happening for providers, and not necessarily all for the better, but these are difficult times, and this is what we're going to have to deal with as providers. We need providers to be reactive to any criticism from the CQC, and where you agree that something has fallen short, you need to be taking prompt action to make it right and document how you're going to sustain that improvement. And in the event that you disagree with what the CQC is saying, you need to make a robust challenge and make your position clear, because whatever CQC conclude about your service will be information in the public domain, and it's very important that it's a true reflection of the service that you provide. That's all from me, so I'll hand back to Laura.
Thanks, Jenny, that was really useful. If anyone has any questions they want me to direct to Jenny at the end, just pop them in the question and answer box at the bottom of your screen. And then we'll move on to our presentation from Anna, which is on the Mental Capacity Act and the Liberty Protection Safeguards. Thanks, Anna.
Thank you, Laura. Yes, so this morning I'm going to be discussing the Mental Capacity Act 2005 with you, but I'm mainly going to be focusing on the liberty protection safeguards which come into force under the Mental Capacity Amendment Act 2019. So the first slide here is the Mental Capacity Act 2005, which is the legislation behind the deprivation of liberty safeguards. And I'm sure you're all aware that the 5 key principles under the Mental Capacity Act are as follows. Number 1, presumption of capacity. Number 2, support to make a decision. Number 3, ability to make unwise decisions. Number 4, best interest. And number 5, finally, the least restrictive option. Next slide, please. So the liberty protection safeguards are going to be implemented under the Mental Capacity Amendment Act, and they will replace the current deprivation of liberty safeguards system. The 5 key principles of the Mental Capacity Act, which I just referred to on my first slide, will remain in place. So nothing will change there. And whilst the Act was given royal assent in May 2019, the implementation of the Act has been delayed until April 2022. Next slide, please. So on this slide here, I've included a summary of what the current situation is under the DOL system and what it will be under the new LPS system. So under DOLs, they could only apply to people who were currently can only apply to people who are aged 18 or over in a care home and hospital setting. Whereas under the new LPS system, for the first time, 16 and 17-year-olds will be covered. And it will also apply to any care setting, including domestic settings. It will also apply to transport. So, for example, ambulances transferring a person from A to B. The supervisory body will become the responsible body, and that will be local authorities, NHS trusts, and the CCG. Next slide, please. So in relation to the LPS authorisations, LPS assessments need to be completed by staff with the necessary skills and experience. And a pre-authorisation review will take place by a professional that's approved by the responsible body. So, for example, an approved mental capacity professional. What's key here is that this person is not involved in the day-to-day care of the cared for person. And once the assessment has been carried out, it will be reviewed by the responsible body and then authorised. Next slide, please. So these assessments will form the basis of authorisation under the liberty protection safeguards. So there's 3. That is, number 1, the capacity assessment. Number 2, the medical assessment to determine whether the person has a mental disorder. And number 3, a necessary and proportionate assessment to determine if the arrangements are necessary to prevent harm to the person and proportionate to the likelihood and seriousness of that harm. Next slide, please. In a recent LPS steering group meeting that took place in October this year, it was decided that the government would not be bringing in the LPS provisions relating to the care home manager role. This care home manager role would have involved the manager arranging assessments and gathering information to determine whether a person could be deprived of their liberty. And the whole reason that this role was designed was so that people who knew the person well and understood their wishes and feelings could lead the LPS process which would in turn reduce the burden on local authorities and CCGs. As I'm sure some of you will be aware, this was always quite a controversial role, and the reason for that is because there were concerns about conflict of interest issues, with some people feeling that managers might lack the independence needed to lead the process. Care home managers are also already extremely very busy in their roles, and this added responsibility would have increased the burden on them. So overall, the removal of this care home manager role under the LPS has been very welcome. Next slide, please. So whilst the care home manager role will not be coming into force in April 2022, the government is going to instead focus on introducing all other aspects of the LPS. And although the care home manager role won't be brought into force, in the LPS steering group minutes, it was acknowledged that staff who know the person very well and care for them every day will still play a vital role throughout the assessment process and during the consultation stages of the LPS process, so that they can help with the decision maker establish what the person's wishes and feelings are. Next slide, please. So the next major milestone in terms of the LPS is the draft regulations. And Department of Health and Social Care officials explained that the government has made a series of decisions about the detail of the regulations, and these will form part of the public consultation in spring 2021, and it will run for a period of 12 weeks. The government will take into account and consider the outcome of that consultation before it makes any final decisions about the design of the LPS and what it will look like in practice. Next slide, please. So in terms of what the draft regulations will do, well, they will set out the role of IMCAs, so independent mental capacity advocates, and IMCAs will have the power to prepare a report in relation to the arrangements or proposed arrangements for the responsible body. There will also be a distinct set of regulations that set out the eligibility criteria and statutory training required to do this role. And the regulations will also include a definition of what is meant by a prescribed connection to a care home. And individuals who meet that definition will not be able to act as an approved mental capacity professional in certain cases. Next slide, please. So in terms of the draft regulations, we'll have the transitional regulations, which will set out the legal framework for DULs and LPS to run alongside each other for the first year of implementation. This means that anyone who is currently, or at that time, subject to a DULs or call to protection order, if they're 16 or 17, will still be able to access the necessary safeguards until that authorisation or order ends. The assessment regulations will set out who is able to carry out the assessments and determinations under the LPS. And then the consequential regulations will amend other pieces of legislation that need updating as a result of the Mental Capacity Act 2019. Next slide, please. So I've given you a brief overview of the main changes in relation to LPS, and that is in relation to the removal of the care home manager role. In terms of key takeaways, it's important to remember that the Mental Capacity Act 2005 is still in force, and so is the existing DULS framework. And it's important that appropriate authorisations are continued to be made. CQC takes compliance very seriously, and if it is found that a deprivation is unlawful, it can lead to CQC enforcement action, potential claims for compensation, and also local authority safeguarding issues. During the pandemic, CQC reported that there was a significant drop in the number of DOLS notifications being made to them. And so it really is a hot topic for CQC at the moment. So something to very much be aware of. My third bullet point here relates to Department of Health and Social Care guidance. Oh, sorry, the light has just gone off here. I hope you can still see me. And that is in relation to the Mental Capacity Act and DOLS during the coronavirus pandemic. And this contains really helpful guidance for providers to help cope with the challenges that they're facing at the moment. And finally, over the next 18 months, while we wait for the LPS to come into force in April 2022, providers should prepare and train their senior staff and managers so that they're ready for the LPS when it does come into force. Thank you very much.
Thanks, Anna. That was useful. Again, pop any questions you've got for Anna in the question and answer box at the bottom of your screen. And without further ado, I'll hand you over to our Managing Director, Paul Ridout, who's going to talk about lessons learned from COVID-19 and the way forward. Paul.
Thank you, Laura. Good morning, everybody. I'm going to finish up today by having a run through how we have seen the COVID-19 pandemic impact on providers and the sort of issues that you're all going to have from day to day. And the first and most important point is that there's been a very significant effect on care services, but it's caused a much greater concentration on some of the day-to-day issues that might otherwise have been regarded as routine and perhaps not as focused as others. But in essence, you apply the same basic principles against the new and challenging guideline. The pandemic is serious. The pandemic is a very important factor in all your businesses, but just apply the principles you would have applied in any other situation that arises. Next slide, please. This is really about policy control in relation to anything that arises in a care home, but particularly the COVID-19 pandemic. There must be a policy to deal with the various issues that arise. And the development and implementation of policies should always be dynamic, by which I mean they should be constantly under review. Experiences should lead to change. Change should be effected in policy and then in practice. Policies need constant and anticipatory review against new challenges and environments. We all know over the last 4 or 5 months, things have changed on a weekly, sometimes daily basis. Government guidance has changed, and our response, your response, needs to take that into account. Not I've got a policy, I put it on the shelf, I know what I'm doing, but how is it working day to day, and does it need to change in a change circumstances? Changes in circumstances require change in policy. Next slide, please. Policies are the remit of the registered people, the provider and the manager. The policy change must be clear and decisive. The provider and the manager must work together with their senior staff, and the staff and anyone interacting with the business, all relevant stakeholders, must know what's expected. So policy changes need to be thought through, created, published, implemented and trained. And that's going to need to be demonstrated, particularly when CQC are coming in on these infection protection control inspections about which Jenny spoke. Next slide, please. The policy control may be influenced, but it is not controlled by government, local government, CQC or other regulators, or even by commissioners. You listen to what they say, you look at the guidance. Unless it's statutory guidance that is required to be carried out by CQC regulators or local government, it's the decision of the registered person, the provider and the manager together to decide what their policy will be. So government may speak about how it would like visitors to care homes to be admitted or not admitted from time to time. But actually that decision will be taken by those responsible for the registration issues. That's the the manager principally working with the owner and the senior staff. So don't be put off by being told by someone that you have to do something because government says so or because it's been read in the press. It's your decision. If it's unwelcome or unpopular, well, if it's the right decision, it still may be the right decision. Next slide, please. Observations and suggestions are nothing more than that. Effective guidance coming from above must be considered. If it's not followed, you should actually think it through, record your reasoning, and if you're going to depart from the guidance or be tougher than the guidance or slacker than the guidance, because after all, every care home, every care service is slightly different. Some may have more staircases and corridors. Some may have greater access to windows and gardens. Some may have various other features which mean that the policy can be implemented in a more generous fashion, or sometimes more strictly, particularly the nature of the particular capacity of service users. Do not ignore, but do explain rationale for acceptance. Primary legal obligations cannot be overridden by contractual, regulatory or government decree unless sourced and explicit. So if somebody tells you to do something, you say, what are you telling me to do? Why are you telling me? What's the authority? As they used to say in America, show me where it is, because it's your decision. Next slide, please. Nothing has changed really in inspections, as Jenny was explaining. Corresponding with inspection is mandatory compliance. Only CQC have the power to enter, the power to make demands, the power to make orders. Other stakeholders, local authorities, even central government, do not enjoy CQC's absolute powers of entry and inspection. Even local authority safeguarding teams don't have those sorts of inspections. They, of course, should be welcomed as visitors to your service from time to time, but you keep control of them as visitors. Just because of the pandemic, that doesn't change the rule, but be careful with CQC. They have amongst the most powerful powers of entry and inspection of anyone. Next slide, please. Restricting and instructing inspectors is a criminal offence, but the criminal offence which CQC must prove and disprove is obstructing without a reasonable excuse. Now, we have considered, debated and written about this. The pandemic may produce a different situation. CQC were for a long time unwilling to send their inspectors with tests of negativity for COVID. Government said CQC inspectors didn't have close enough contact with service users, so there wasn't a need for that to lead to them being treated as key workers. We think that was wrong, and we think you should treat an inspector as any other inspector, but bearing in mind that this visitor is a visitor who's entitled to come in and force. So you might want to consider requiring recent negative tests, placing restrictions on particular activities, controlling where inspectors go, controlling the interaction with residents, or anything else that may be particular to your particular circumstances. You need to be careful, but if you have thought this through, if you have explained it, if you have given notice to CQC, then it may well be reasonable for you to say, given that you're not complying with our local arrangements, we're not going to let you in on this occasion. Go and comply with our arrangements. But be careful, don't just use it as a blanket approach. So next slide, please. CQC can enter and inspect. CQC can interrogate by telephone. Is it mandatory? Well, you would be unwise not to do it. Is the content of what you say binding? Yes, it is. Be very careful. Be just as careful as you would be if you were talking to a CQC inspector at feedback or interacting with a CQC inspector during a physical inspection. May you take notes? Of course you can, and you should, because you will want to be sure that you know what was said to you and what you said and what the tenor of the conversation was. CQC has the power to request information and to request explanations. They should do that in writing, and they should make it clear that they're requesting information and explanations through the statutory powers under Section 64 and Section 65. Is this the beginning of a change? Maybe. CQC view the time, the delay and the cost of inspection as being something that is very burdensome to them, and they don't like challenge, as you know. Can you ban the inspector? Probably, well, in most cases, no. But if you follow the guidance that we've given, if there's a serious and real concern, either to your staff or to your residents or to maybe to the inspector, then you can give it serious consideration. Next slide, please. Visitors, well, we've got CQC, staff, families, friends, tradesmen and suppliers. All of these people will have slightly different needs. Tradesmen will need to come in for particular tasks. Preparation will need to be made that the areas they're visiting are clear. Suppliers may be able to deliver. Friends and families, you may well require, and should in our view, require recent negative tests. Staff should, in accordance with government guidance, probably not work in other care homes, and staff should be tested regularly. CQC have to be allowed in, but CQC may be subject to reasonable requests, and they are now presenting with inspection, with negative test rules. Control the access so that you control the safety of your staff and the safety of your residents, most important. Consider those policies, set the rules and operational practices, and the only exception is the CQC, which I've dealt with in detail. Next slide, please. Now, I wanted to spend some time, because it's in recent attention, on the approach to DNA CPRs, which is do not attempt pulmonary resuscitation. At one time, this was shortened to DNA R without pulmonary in such prominence. What is important through all of this is to clear the fog of debate and discussion and dissension away. Whether or not any form of resuscitation is appropriate or used is a matter of clinical judgment on basic principles for the clinicians who are present when the judgment is being made. Any advanced decision or statement that particular actions will not be taken is extremely dangerous and should not be put in place without careful consideration and careful case-by-case implementation. That's quite clear from what CQC are saying in their initial report on DNA CPRs, which came out just last week. If the particular service user has capacity, it's their choice whether they undergo what may be a serious and life-threatening assault, and that choice should be honoured. If they lack capacity, then a decision needs to be taken in their best interest. It may be obvious, but it should not be a matter of, we've got a piece of paper in a file that says we're not going to do this. That should never supplant the circumstances at the particular time. And when the decision is being made for somebody who lacks capacity, the relevant professionals should be making that decision. If you make the wrong decision, there are serious consequences. You could kill the service user by inaction, you could kill them by action. And this overlaps very much with the debate on assisted dying. People should get the right treatment, and the right treatment maybe do nothing, but it's case by case. And I'm very suspicious, and I recommend everyone against allowing documents to be put in service user files, which in some ways might suggest to somebody, even an ambulance crew, that they're not going to bother to do what they might otherwise do. So be very careful of these and apply basic principles. Next slide, please. COVID-19 is just another facet of infection control. When you're thinking about what you're doing, be as close as you can to legal requirements. Distinguish what is the law from what is guidance, and whether that guidance is mandatory either for the person who is regulating it or implementing it, or if that guidance is nothing more than a suggestion which you can factor into your decision making. Beware of anecdotal opinion, particularly that may come from ill-informed or even perhaps well-informed visitors, and certainly from the media or from press comments. You should make your own policies about infection control. You should demonstrate them and you should explain them. You should have your own particular risk assessments, and having made those risk assessments as simple as possible, you should have a clear risk management plan to address each of those risk assessments. Listen to others and review those risk assessments and risk management plans regularly, and have them available for delivery to your regulator, the CQC, perhaps commissioning authorities who might be inquiring, or others. That is the approach there. Next slide, please. COVID-19 has had a significant impact. There are reduced occupancy levels. There are increased pressures on staffing. There is reduced scrutiny by the regulator in some ways, but enhanced security in others, and a hugely increased focus on the all-important feature of infection control. As Jenny was saying earlier, CQC are targeting infection control, and we are seeing time and time again that otherwise good homes are being downgraded and effectively stigmatized because of relatively isolated staff errors. Staff taking their masks off, staff not wearing masks whilst smoking in meal breaks outside. These sort of things are all featuring, which one wouldn't have expected to be a strong feature in a past situation. So be very well aware of these changes. Next slide, please. A changing landscape in how ratings and inspections are conducted. There will be more inspections, there will be shorter durations, and it remains to be seen what the new relationship will look like post-April 2021, when we hope that the pandemic will be on the wane, certainly with the introduction of vaccinations, which is an important feature about which we've had some questions. It's going to be interesting to see how CQC develop, whether they move towards shorter inspections, more requirements, or whether they open up back into being a more interactive assist and support the provider to provide a good service. Next slide, please. Time for questions. I see Laura's appeared. Hi, yep. Laura. Thank
Just
you,
like
everyone.
magic. Back again. Thanks, everyone. And thanks, Paul. I'm conscious of the time. This is the opportunity for questions. I've seen a few pop through. Actually, just before we leave, Paul, and just picking up on something that you said a moment ago, a question for you, if you think you're able to answer this, is do you think that it will become mandatory for staff to have a COVID vaccination to work in care going forward?
Big question. Glad somebody's asked it. Of course, it can't become mandatory as a matter of law without specific legislation or legal requirement. There are many, many issues about whether vaccination could be imposed. Of course, vaccination is itself an assault on the individual. So if somebody refuses to be vaccinated, that cannot be forced. But it is obvious that if somebody doesn't want to be vaccinated and leaves themselves at greater risk, then there must be consequences for them, particularly in terms of individual risk management, because the risks of someone who is not vaccinated are clearly going to be different in different ways and maybe higher than others. So it may have implications at an employment level for where and how that person can be employed, and when they can come on duty, who they can work with, and the level of disability or dependency they can cope with. So I don't see it's possible to make it mandatory, but there will be consequences increasingly for people who do not take it, and providers will want to be thinking about what their policy in relation to vaccination will be as the rollout increases.
Yeah, definitely interesting and topical in light of the rollout that's starting now. Thanks, Paul. I'm just going to do one question for each of our other presenters, and then we'll endeavour to answer the other ones on our website. So if I could move to Anna, I'm back on the liberty protection safeguards. Anna, what will happen to people who are under adults when the LPS comes into force in April 2022?
Thanks, Laura. So DOLS and LPS are going to run alongside each other for the first year of implementation. So anyone who is currently or at that time subject to a DOLS or court of protection order, if they're under 18, will still be able to access the necessary safeguards until their authorisation or order ends. Thanks.
Great, thanks. Something to definitely keep an eye on. Yet another change for providers to keep on top of in the coming times. Finally, Jenny, can I just pick up on something you talked about, and I think something that we've all been experiencing in the office recently with providers, and it's on the issue of urgent action. And someone has asked, how often do the CQC accept responses to letters of intent and drop the threat of enforcement action?
In our experience, when providers come to us at the moment they receive the letter of intent, we can guide them into what type of response should be submitted to the CQC. Without blowing our own trumpet, every case I've dealt with at that stage has been successful, and it's avoided Section 31 action. And that's simply because we can guide people in the type of action plan, detailed, people taking ownership of each task, dates and evidence to be provided to the CQC to allay their concerns, as well as a covering letter that kind of addresses the points of concern where you agree with those issues and just goes some way to reassure the CQC. So in answer to the question, I would say often when your response is robust, detailed and seriously considered, can you avoid enforcement action? I think more people are actually unsuccessful in the letter of intent response. It's when they haven't done it in a detailed fashion, they've done it quite quickly overnight, and they haven't engaged legal help. Even if it's just getting somebody to read it and just look at the plan. What I would say to people is be very careful about what you submit, and if you are saying that you're going to do something, you must do it, because the CQC are likely to come back in and inspect very shortly after you submit that plan. So it can be successful, but it's up to you.
Yeah, I've certainly seen that with providers that I've been assisting recently, that the CQC have come out very quickly after receipt of an action plan in response to a threat of Section 31. So yeah, I think that's really important that you must do what you say you're going to do in that action plan. Thanks, thanks everyone. Jenny, can I just have the last slide? Just conscious of the time, we've only got 2 minutes left, so I'm not going to put any more of the questions to the panelists live, but we will share them and get the information up on our website. But please do, if you have any questions or you want to engage with us, or you want advice about any of the issues that we've talked about today, contact us. A good channel for updated content is our Twitter profile, which is Ridouts Law. We're also on LinkedIn, and today's webinar, including the slides, will be available by video on our website. There's also some other video resources on our YouTube channel. So I think in the last minute, all it remains for me to say is thank you very much for joining us. Thank you if you've come to the series of events. Please do give us some feedback. We will be reviewing our programme of events very carefully for next year. It looks like face-to-face events are still a bit of a long way off, so no doubt there'll be more webinars to come. So if there are any other topics that you would like us to cover, please do let us know. Thank you so much, and now it's December, I hope you're starting to feel a little bit festive, and we can all take on the good news about the vaccine rollout and look forward to a much more positive year coming ahead. Thanks very much.